Morning, ladies and gentlemen. I'd like to get us started right on time this morning so that we can get out right on time this afternoon. I'm a program lawyer with continuing legal education, and I'd like to welcome you to this program, Criminal Law and the Charter. I'd like to take this opportunity to thank today's faculty for coming to speak to you today, and also for preparing the very exceptional materials that you've been handed out. With that all said, I'd like to take this opportunity to introduce you to the co-chairs of today's program. Ken Campbell has been counsel in the Crown Law Office Criminal for the past 10 years. His practice has always been restricted to criminal law, and he's focused primarily upon appellate work before the Ontario Court of Appeal and the Supreme Court of Canada. Jeff Manishin is a partner at Ross & McBride, where he practices criminal law. Mr. Manishin is certified by the Law Society as a specialist in criminal litigation, and he has also asked me to make sure that I point out that he's a producer and an actor. He was in the Hamilton Lawyers Club original production of 12 Angry Men in 1983. So with that said, I'd like to have Jeff come up and conduct proceedings from here.
Thank you, Laurel. On behalf of Ken Campbell and myself, I would like to welcome everyone to the first of what could well be a series of long-needed programs designed to inform and to educate the members of the bar and the bench on developments in the Canadian Charter of Rights and Freedoms, or that legislation which some cynics would say is the greatest make-work projects for criminal lawyers since the development of the criminal code. It's good to see so many of you here on a Saturday morning at this early hour. Over the last few months, we've been very fortunate in gaining the participation of a number of outstanding panelists and speakers, and I think you'll find that the materials are excellent. All of the topics that we have developed for you today are timely and complex, so we know that you will benefit from what our speakers and participants have to contribute. The first panel will focus on the developments in the matter of disclosure, not only since the decision in Stingcomb and the Queen, but the recently released report of the Advisory Committee to the Attorney General on charge screening, disclosure, and resolution discussions chaired by the Honourable Arthur Martin. We are fortunate to have two of the members of that committee on our panel this morning. First, chairing the panel will be the Honourable Mr. Justice Brian Trafford, who is seated in the middle. Mr. Justice Trafford was, in his former life, an Assistant Crown Attorney in Brampton, a Senior Counsel with the Crown Law Office, and recently became a member of the Ontario Court of Justice General Division, and as I say, he was one of the members of the Martin Committee. To Brian's immediate left is Brian Gover. Brian Gover is a member of the Crown Law Office Senior Counsel. For the last 2 years, he was an executive legal officer with the Ontario Court of Justice General Division. Most notably, Brian was the counsel who was responsible for unloading boxes and barrels of material on defense counsel in the matter of Regina versus Moran, where the disclosure proceedings were complex, difficult, involved, and Brian had considerable experience in that area. An effective counterpart for Brian Gover on this matter is Tim Breen. And Tim's to the far right, or to the right of Mr. Justice Trafford. Tim is an associate with the firm of Rose and Fleming. If Tim appears to be a little bit red in the face today, it's because he's recovering from the media glare in the course of his application for disclosure on the matter of Regina versus Teal, which will promise to be another difficult and challenging case for him. And to the left of Brian Gover is Mr. Joseph DeFilippis. Joseph works with the Department of Justice in the Toronto Regional Office. He's Senior Counsel and Deputy Section Head of the Criminal Prosecution Section. He, too, was a member of the Martin Committee. So without further ado, we welcome our panelists and look forward to their comments.
What we want to do here today is discuss disclosure after the Martin report, given its historical context. We intend to spend the bulk of our time, as time permits, in dealing with specific issues that come up from time to time in the course of a prosecution. But before we get into those specific issues, there are a number of preliminary points that we think will be helpful to your understanding of those issues. The first one really is the historical context of the Stingcomb decision itself, and consequently what we want to do is briefly summarize the legal principles relating to disclosure prior to Stingcomb. Brian?
Thank you. The Criminal Code, of course, provides very little guidance as to the scope of the prosecutor's disclosure obligation. In fact, the Criminal Code guarantees nothing else but the accused's own statement and a copy of the indictment. The movement toward some statutory framework for disclosure and its obvious delay is what, in my view, has resulted in the enactment of the broad regime of disclosure which is set out in the Stingcomb judgment. The Marshall Committee had recommended in 1989 a very broad panoply of disclosure rights, rights which would be available without request, and disclosure to be made prior to election as to mode of trial or plea. And you can see that the Marshall Commission recommendations really are basic to the understanding of the Stingcomb case. Well, statute provided little guidance, as I've said. What about the common law? Well, traditionally, it was held that disclosure prior to trial was a discretion in the prosecutor, and disclosure at trial was a discretion in the trial judge and not a right in the accused. It was recognized prior to Stingcomb that there was certainly an ethical dimension to the disclosure obligation, and Commentary 9 to Rule 10 of the Rules of Professional Conduct, which are applicable in this province, expressly recognizes that the prosecutor should make timely disclosure to the accused or his counsel of all relevant facts and witnesses known to him, whether tending towards guilt or innocence. Well, of course, the Charter of Rights had been in effect for 9 years prior to the Stingcomb case having been decided. It was argued over those 9 years that Section 7 of the Charter, which of course guarantees the right to fundamental justice, broadened the scope of the prosecutor's disclosure obligation. And in Ontario, it was consistently held that the Charter did not create broad discovery rights in the civil sense of all facts within the knowledge of the police or the Crown and somehow related to the crime in question. In my view, the Ontario courts appear to have reasoned that constitutionalization of the long pre-existing right to make full answer and defense did not broaden the scope of the prosecutor's disclosure obligation. Well, given the common law and given the paucity of guidance provided by statute, it became necessary for attorneys general to issue guidelines and later directives concerning disclosure. And in this province, the Honorable Roy McMurtry issued the first disclosure guidelines in 1977. Those were revised in 1981 and remained in force until 1989, when they were replaced by a disclosure directive. Some judges tended to interpret the directive as if it were, in effect, law. They would give it the force of statute. That has been very much the experience in the United Kingdom, where the Attorney General's guidelines are considered when the Court of Appeal determines whether a material irregularity has occurred in the course of the trial proceedings. The English law is also interesting in that it presents a marked departure from our law insofar as in England, apart from alibi, there is an instance in which the defense has to provide disclosure. The Police and Criminal Evidence Act of 1984 has obligated defense counsel to make disclosure of expert reports. And additionally, because of a similar lack of guidance from statute, The Royal Commission on Criminal Justice, which issued its report at about the same time as the Martin Committee released its report, has recommended a statutory framework for disclosure in that country, which would include a further requirement that the defense disclose the substance of its own case. I'll touch briefly on the American law. The cases dealing with disclosure in the United States are based on the Due Process Clause in the 14th Amendment. The foundation case is Brady in Maryland, and it was held there that suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecutor. So there the court has created a request-driven disclosure regime in relation to material evidence. And for me, one of the most interesting aspects of the American law is the interplay between the nature of the request, that is the degree of specificity of the disclosure demand, and the court's determination of materiality. What is material in the American law will depend not only on the nature of the undisclosed evidence, but also on the type of the disclosure request made.
That was the general historical context that the Supreme Court of Canada was dealing with in Stingcomb in 1991. Stingcomb was a case where the Crown, as you'll recall, had deliberately declined to produce a witness's statement to the defense when requested. It made its way through to the Supreme Court of Canada, and we have there a decision of real significance to the law of disclosure. Tim, can you summarize that for us, please?
Sure. The facts in Stingcomb are summarized briefly at page 18 of the paper, and I won't really go into it in any detail, but the most significant feature of the case is that it recognizes a constitutional right to disclosure, and this is a fundamental change from the pre-Stingcomb experience, both since the proclamation of the Charter and the pre-Charter cases that Brian Gover has referred to. With the recognition of a constitutional right to disclosure necessarily follows a duty upon the prosecution to make disclosure. In the Stingcomb, the case itself dealt mostly with the facts and how the principle should be applied in that particular case, and the court really gave not much in the way of assistance in terms of how these issues are to be resolved both substantively and procedurally, but what the court did do was to provide a number of principles to be applied with respect to this area, and I can just briefly summarize those. First, the Crown is obliged to make disclosure of all relevant information. And the use of the term information is critical because it's distinguished from relevant evidence. So the obligation to disclose goes beyond simply what may be admissible evidence at trial and relates to basically anything of significance to the case that the Crown is in possession of. In terms of timing, the court stated that disclosure should be made before the accused is called upon to make an election or a plea. And this has particular significance in terms of the procedural context in which rights of disclosure may be litigated. Third, there is an obligation upon defense counsel to make a specific request for disclosure. And this applies to what Brian was saying earlier about it being a defense-driven system. Also, from a procedural standpoint, what's significant of the nature of the requirement of defense requests is that now that we're dealing with a constitutional right, we're dealing with issues that can be litigated both at trial and at appeal. And it's critical to create a record for the proper presentation of these issues. So defense, when making requests for disclosure, have to be keen to the fact that really what they're doing is creating evidence. They're creating a record. So the requests have to be specific and they have to be pointed so that when the issue gets to trial or further on appeal, you have an evidentiary basis. The obligation of the prosecution to make disclosure also encompasses a discretion as to the withholding of material on grounds of privilege or safety of witnesses. Now, while recognizing that the Crown has this discretion, the court also recognized that this discretion is subject to review by the trial judge. So the procedural difficulty of how are these issues going to be litigated? How is the defense supposed to make claims of relevance of material that they have no access to? An analogy to some extent can be drawn to the wiretap cases where the defense was in the position prior to the Playford case in this province of not having access to the affidavit in support of an authorization, but yet having been put in the position of having to make a prima facie case of fraud under the Wilson decision. So there's some analogy there, and it creates a procedural difficulty that Stingcomb doesn't answer. And right now, we're in the process where the courts are having to deal with both issues of substance as to rights of disclosure and perhaps just as important, procedural considerations as to how these things are going to be worked out. And to some extent, we're seeing the vitality of the common law in that there's no statutory framework or no constitutional framework to answer these questions, and the courts and counsel are left to work the solution out themselves. I think that's all.
The decision of the Supreme Court in Stingcomb was readily assessed as being a most important one for the system, and as a result, the Honourable Howard Hampton, the Attorney General for Ontario, in June of 1991 appointed a committee to look into not only disclosure practices in Ontario, but also other pre-trial practices that were impacting on the system. Joe DeFilippis was a member of the committee, and Joe, I'm wondering if you can comment on the committee and its processes generally at this time.
Yes, good morning. We'll discuss the report in the discussion that follows, but if you turn to page A55 of your materials, you'll see the disclosure directive. And disclosure was one of three parts to the report. The most important of the three dealing with screening, disclosure, and dispute resolution. Taken together, the report seeks to change the focus of criminal practice by emphasizing the early stages of the proceedings. It's felt that by so doing, both fairness and efficiency will be promoted. The report was, the committee was chaired by the Honourable G. Arthur Martin with 14 members representing the Crown, the Defence, and the police. There was broad consultation and much deliberation by the committee, and I commend to you the 500 pages of commentary to the report. It's really a starting point for any of your research dealing with any of those three areas. The report hasn't been accepted yet and therefore has no formal effect. Given the stature of the chairman, however, I predict that the impact will be significant, notwithstanding the Attorney General's response to the report.
Let's then begin to discuss a number of particular issues that become important in the system. The first one relates to the obligation of the Crown, if any, to review the course of the investigation prior to making disclosure. Can the Crown, for example, merely assume that the brief that was prepared by the investigator and given to him or her is a sufficient basis to meet the Stingcomb principles? Brian?
We now have a clear obligation as prosecutors to disclose all relevant information. And information is important as a word used in the judgment because it need not necessarily attain the status of evidence in order to be the subject of the disclosure obligation. Secondly, the Supreme Court of Canada said that the prosecutor should err on the side of inclusion, that is, err on the side of disclosing the information. So, in my view, it's now clear that the prosecutor cannot meet an argument as to sufficiency of disclosure by simply saying to defense counsel and to the court, you have everything I have. There is an obligation on the prosecutor to review the course of the investigation. And importantly, because the disclosure obligation is a continuing duty, that duty on the prosecutor must encompass the obligation to review the course of the investigation at critical stages in the prosecution itself. So, for example, it may be that in light of a particular line of cross-examination at the preliminary inquiry, it is now apparent to the prosecutor that some information is relevant, which previously, of course, couldn't have been known by the prosecutor to be relevant. In those cases, I would argue the prosecutor is under an obligation to review with the investigators the course of the investigation and determine whether there is any further information out there which may assist the defense. And similarly, of course, at a pretrial conference, there may be some indication from defense counsel as to matters of particular relevance to the defense. And again, the counsel of caution is that the prosecutor should sit down with the investigators at that point and review the investigation. And of course, at trial, as avenues of defense become apparent once again, this obligation kicks in. And as the Marshall case itself graphically demonstrates, not only is the disclosure obligation a continuing one, but in many cases it will survive the verdict itself, so that appellate counsel for the Crown may also be in the position of contacting the investigators in light of some indication from counsel for the appellant that some information may be important to the defense, may take the form of a fresh evidence application on the appeal.
Joe, do you wish to comment on that, and in particular, what systemic ramifications does this proposition have for the operation of the Attorney General's staff in Ontario?
Recommendation 38 of the report provides that the Crown must make reasonable efforts to determine the sufficiency of disclosure, and that must be understood in the context of the Crown's relationship to the police. We don't have to reinvestigate the offense, but we must carefully review the material and provide the police with advice and perform a follow-up role if the material isn't sufficient. That's going to pose obvious problems for the Crown. What we've done at the Department of Justice is to perform that duty in advance. We provided the police with a checklist of materials that we want in every brief. And that's contained at page 67 of your materials. And that's how we are going to deal with the systemic problem, which this report obviously imposes upon the Crown.
It's clear as a result of Stingcomb that the Crown does have this obligation to disclose information as opposed to evidence. Is it appropriate for the Crown, in reviewing the course of the investigation, to distinguish rumor from information? Brian?
In my view, the safest course is for the prosecutor not to draw any such distinction between rumor and information. But I think the prosecutor is entitled to bear in mind the cases such as Gingras, the Alberta Court of Appeal case referred to in the paper, and others which hold that the police and the Crown are not cast in the role of an investigative agency by the Stingcomb decision. And consequently, I would disclose the information, even if it is in the nature of a rumor. I would indicate to defense counsel, however, that it is up to him or her to run the information down and to make the determination as to whether it is something which could be elicited as evidence.
Tim, do you wish to comment on the distinction, if any, between information and rumor?
Well, what is significant in terms of the substance of disclosure is that there's no division between what's in the Crown brief and what information the police have. As state agents, it's indivisible. So it's clear that any information that the police are in possession of, the Crown is obliged to reveal. Now, where there is a gray area, is as Brian Gover's referred to as, is there a positive obligation upon the police to investigate and run down leads. And I suppose it's like beauty, it's in the eye of the beholder. Does a particular question involve a positive obligation, or is it something that the police are obliged to provide? And that is going to be a tension in the law that can only be decided on a case-by-case basis. In other words, it's very easy to say as a principle that the prosecution is not obliged to collect information for the defense, but at what stage do you have a problem of willful blindness, say, where there is an obvious area of relevance that the police do not acquire because they'd rather not know about it? So that's something that can only be resolved on a case-by-case basis.
Let's move now to the obligations of the defense counsel in this new system. What obligations, if any, does the defense have relating to the disclosure process? Tim?
What flows from both the decision in Stingcomb and perhaps more expressly the Martin Committee report is the notion that one of the objects or benefits of a requirement of disclosure is the tremendous returns to the system in terms of efficiency. And if this is going to work and if these goals are going to be obtained, there's a real obligation upon the defense to participate in the system. And by that I mean there has to be initially a request for disclosure, and we all know that you'll receive a copy of the Crown brief, and instead of letting it sit in your file and read it the night before trial and go into court and say, hey, there's something missing, I need more information, if there are going to be returns of efficiency, defense counsel has to review the disclosure promptly. And if there are material omissions or things that the defense want, they have to respond with a specific request to the Crown to say, these are additional matters of disclosure which I am seeking. And through this cooperation, and obviously there's a corresponding duty on the Crown's office to have a Crown in position with knowledge of the file to review the disclosure, to review the requests and be in contact with the police to acquire the information and facilitate its disclosure. If all of this works together outside of the court process, when you get to court, you have the case ready to go. And only through this type of out-of-court effort will the system see these positive returns of efficiency. The other element to it is what I touched on before, and that is creating a record that you will not be in a position to advance or to argue of non-disclosure issues on appeal unless you have an evidentiary foundation for the argument. And the only way you can create that evidentiary foundation is by papering the Crown with specific requests. If there's a failure to make requests until the day of trial, you may be in a difficult position on appeal to say, my rights have been breached or my client's rights have been breached by non-disclosure. The failure to object in these circumstances may very well be taken as a waiver of the right.
Joe, could you comment on the obligations of the defense counsel from the perspective of the Crown? What can the Crown properly expect from defense counsel, and in particular, what should the Crown do in the event that he or she believes that the defense counsel is not meeting its standards?
The Crown can expect three things from the defense, and they're reflected in the Martin report. First of all, a timely request for disclosure. Secondly, defense counsel must narrow and define the issues to assist the Crown in determining relevance. And thirdly, the defense must continue to have a meaningful dialogue with the Crown throughout the disclosure process and during the resolution discussion process. Without that dialogue, the Crown is really unable to determine, in many cases, what is relevant from the defense counsel's point of view, and the Crown will be able to say that there has been no failure to discharge its duties, assuming a minimum disclosure has been made. So that is the real onus upon the defense, and that's what the Crown can and should expect of the defense, is a real dialogue.
Just looking at that dialogue issue for a moment, is it ever proper for the Crown to require from the defense as a condition precedent to giving disclosure an undertaking to limit the preliminary hearing?
No, the right to disclosure is unqualified, and so it's improper for Crown Counsel to extract admissions from defense counsel as a condition for the giving of disclosure. Having said that, defense counsel does have a very real duty to read the disclosure, to review it, to follow it up with his or her client, and then to attempt to narrow the issues, resolve the case if possible, and talk to the Crown, to have a real discussion with Crown Counsel. And that discussion, in my experience, has not been held in the past, and the fault lies with both Crown and defense. It's been my experience that until the trial, neither party is really prepared to discuss the issues.
Tim, is it ever proper for the Crown as a part of this dialogue to say to the defense counsel, in effect, I'll give you the materials that you're entitled to, provided that you keep them away from your client, the accused, whom, so the Crown would say, I believe presents real risks to witnesses in this matter?
I suppose the short answer to that question is that the constitutional right is that of the accused, not counsel. So it's very difficult from a defense standpoint to consent to any restriction on the dissemination of disclosure material. Concerns about the safety of witnesses or protection from harassment really can be accommodated by deleting addresses, and we all know that that's a standard course for Crowns in making disclosure. But defense counsel should be very wary to make any undertakings limiting the manner in which they can use the material, particularly along the lines of allowing their client to have access to it. And obviously, on a case-by-case basis, you're going to have different clients who have different desires to participate in the case, but you should be very careful not to make any undertakings that limit the use or access by the client, because it is their right, not yours.
One of the issues that was brought to the attention of the Martin Committee was the improper dissemination of disclosure materials to the public. For example, there was some information before the committee that the statements of victims to sexual assaults were sometimes found posted in schools and other such public places, or alternatively, some defense counsel, for one reason or another, were taking the disclosure materials and presenting them to the media and being interviewed in the public forum in relation to the allegations being made against the client. The committee was forced to consider those circumstances, and it was in that context that the Honorable G. Arthur Martin made some comments about undertakings relating to keeping disclosure materials in secure custody. Is it ever proper for the Crown to seek such undertakings from the defense? Tim?
Well, I think it's a good point. Obviously, the material is provided for the purposes of making full answer in defense, and counsel is required to use the material for that purpose. So the committee, in my view, is quite correct in stating that there should not be public dissemination of disclosure material. The problem, I suppose, that you really have is can you control what your client does with it, and that's the tension. And I suppose if counsel is of the view that their client may have other intentions with the material, then you have to be careful. But you're really put in a difficult position because it is the client's case and it's his constitutional right. But certainly from the standpoint of counsel's conduct, they should not disseminate the material outside of the realm of preparation for defense. So obviously if psychiatric reports or things of that nature are provided by the Crown, it's obviously open to defense to retain other experts and provide them with the material because it's in the context of preparation of the defense. But there shouldn't be any public access to material provided by the Crown.
May I just add to that, Judge Trafford, that the report speaks to that and requires that defense counsel not leave in the unsupervised possession of the accused the disclosure materials. The accused is entitled to the information. The accused, in my view, and in the view of the committee, is not entitled to have the disclosure materials. And so there's a positive obligation on defense counsel to maintain custody of those materials and to, of course, discuss it and provide access to it to his or her client. And that would presumably guard against the improper dissemination of the materials.
Now, despite the fact that the Crown has those obligations and the defense has corresponding obligations, no doubt problems will arise from time to time prior to trial. What is available to the defense prior to trial, that is, at some point in time, either before the preliminary hearing or during the preliminary hearing, to seek the intervention of a court to correct what it sees to be defective disclosure by the Crown? Brian?
A significant omission in the Stingcomb decision is the fact that it doesn't even refer to Patterson, the 1970 Supreme Court of Canada case, which held that the powers of the judge presiding over the preliminary inquiry, as delineated in Section 537 of the Criminal Code, do not include the power to order production of statements. So on one hand, the Supreme Court of Canada has indicated for the first time in Stingcomb that the right to disclosure is a constitutional right guaranteed by Section 7 of the Charter. On the other hand, it appears that the prevailing law, the pre-existing law that is, that the preliminary inquiry judge was not a court of competent jurisdiction within the meaning of Section 24(1) of the Charter in relation to disclosure matters still applies. Given that the Supreme Court of Canada a few months ago, in the context of the breathalyzer legislation, held that that legislation, that is those provisions in the Criminal Code, must now be interpreted in light of the manner in which it is considered disclosure obligations in Stingcomb, that is, in light of Section 7 of the Charter. In my view, the time is ripe for Patterson to be re-argued in the Supreme Court of Canada. In my view, the argument can be made in the right case that the judge presiding at the preliminary inquiry must have the power under Section 537 as a necessary concomitant to the power to regulate the course of those proceedings to order disclosure. Now, I hasten to add, though, that as the law now stands, the preliminary inquiry judge remains a judge who discharges purely statutory functions and therefore is not a court of competent jurisdiction.
Tim, let's assume that you make the decision not to make that argument before the judge who's doing the preliminary hearing, but rather want to, at these very early stages, go to the general division as a court of competent jurisdiction and seek relief there. What is the jurisdiction of that court to intervene at that point in time?
Given that the right of disclosure is constitutional, you are bound by the jurisdictional limits imposed under the Charter. And as Mills states, only a court of competent jurisdiction can give relief. So when you're at a pre-trial stage at the preliminary inquiry, say, the only court that can grant relief is the General Division Court as the superior court of criminal jurisdiction. Mills recognizes, particularly Justice Lemaire's decision, and a portion of it is excerpted in the paper, that in exercising this residual discretion, the superior court has to consider matters of urgency. And to the extent that to be effective, disclosure has to be timely and prompt, the defense can be in the position where if they do not receive disclosure prior to the preliminary inquiry, their ability to make full answer in defense may be frustrated. So in that context, you can apply to the General Division and seek relief from a superior court on that basis. There is precedent for such an application, and it's referred to in the material, a case called Laporte out of Saskatchewan. So the jurisdiction is there. It's just up to the defense to create a record to justify the superior court granting a remedy at that stage of the proceedings.
Many superior courts across Canada have taken the position that although the court does have jurisdiction to intervene at that early point in time, it ought not to do so in the absence of exceptional circumstances, but rather should defer to the trial judge to permit it to rather to assume its jurisdiction at that point in time, deprives the parties of appellate remedies and may be otherwise seen to be disruptive in an interlocutory sense of the orderliness of the litigation. What I'd like to focus on in any event is what's the practicality of bringing a matter before the general division? What should the materials be that the defense presents to the court in order to seek such relief? Could you comment on that, Tim?
Well, I think first you have to demonstrate the element of necessity. You have to establish the materiality of the material that you're seeking by way of disclosure and show somehow that the failure of the court to order disclosure at this time would frustrate the defense right to make full answer in defense. The courts have recognized that the preliminary inquiry can be used as a vehicle for establishing potential charter applications at trial, and if the preliminary inquiry is to be effective, presumably the defense should have access to all material at that stage of the proceedings. Equally, if you are so far distant from the trial court, you're faced with the alternative of getting the material only at trial, and if the defense can demonstrate that the late disclosure of that material or disclosure of that material only at trial would prevent investigation and full preparation, then presumably you would be in a position to contend that the general division should exercise that discretion. So it's necessary to have material available, both in terms of specific requests for disclosure, as well as a position with respect to the circumstances of the case to demonstrate the necessity to have that material at that time.
In this hypothetical situation, of course, the Crown has made the decision not to give certain information to the defense. How can the defense discharge its evidentiary and persuasive burdens in the application to the general division if it doesn't have the information? Brian?
The proposed directive indicates in paragraph 16 that in those circumstances, Crown Counsel has the obligation to advise of any decision made not to disclose information in his or her possession. Crown Counsel should also indicate the importance of that information and must advise the defense of the specific nature of the information not disclosed, unless in doing so the Crown would reveal the identity of an informer, jeopardize anyone's safety or security, or subject them to harassment, or compromise an ongoing investigation, or reveal police investigative techniques. And furthermore, upon request, Crown Counsel should take other reasonable steps necessary to facilitate a review. And clearly the committee, in making this recommendation, has recognized that in the circumstances which Tim has raised, defense counsel is in a very difficult position in arguing for disclosure of information not otherwise known to him or her.
May I just add, Judge Trafford, that the committee also assumed that these kinds of disputes would be minimal, would be rare, if there was a real dialogue between defense counsel and the Crown. If the Crown has discharged its obligations properly and made a record of the disclosure given, and if defense counsel has reviewed that carefully, discussed it with his or her client, and then made very specific requests of Crown Counsel pointing out the inadequacies in the disclosure, if there are any, the committee assumed, and I think it's fair to assume, that there would thereby be very few disputes. The matter could be resolved between counsel. And if it couldn't be resolved between counsel, you'd then have a very clear record to put before the motions court judge. So it's imperative that that dialogue continue, or exist rather, or else the motions court judge is going to be in a very difficult position and won't be able to resolve the issue.
Let's move on to another issue, and it relates to the discretion of the Crown to withhold information or to delay its disclosure. The Stingcomb case clearly acknowledges that the Crown does have some such discretion. Practically speaking, one of the most difficult factors for the Crown to deal with in either withholding information or delaying its disclosure arises from the privacy concerns of the victims of the offenses that are otherwise before the court. Brian, can you comment on the discretion of the Crown to withhold or delay information?
Certainly the most common of those situations will be where the Crown has opted to delay disclosure, and even those instances will be rare. As Mr. Justice Sapinka pointed out in the Stingcomb case, the harsh reality of the criminal process is that people who would rather not have personal information disclosed, who would rather not testify, end up testifying, and in many cases, given the need to balance the accused Section 7 rights with interests of victims and other witnesses, even informants will have to testify. So generally tracking the language of Stingcomb, the Martin Committee has recommended that the discretion to withhold disclosure be limited to instances in which the prosecutor has reasonable cause to believe that either some area in which the law of privilege would come into play would arise, or there's a real need to preserve investigative techniques. And secondly, the discretion to delay disclosure would arise where the prosecutor has reasonable cause to believe that delay is necessary to protect the safety or security, which includes protection from harassment of persons who have supplied information or to complete an investigation. And as the committee pointed out, reiterating the language of Stingcomb, any delays in disclosure should be rare, and that includes delays which are caused by the need to complete an investigation. So to answer your question directly, the reality of it is that the privacy interests of victims will almost inevitably be sacrificed in favor of meeting the obligation to disclose and satisfying the obligation as it's been interpreted arising under Section 7 of the Charter.
Although it's clear that the Crown does have that discretion, Stingcomb makes it equally clear that the Crown must facilitate a review of the exercise of that discretion by a judge. How does the Crown go about facilitating the review of the exercise of its discretion? Joe?
The Crown must make a written record of, keep a written record of what has been disclosed to the defense and what has not been disclosed. The Crown can withhold where there is a privilege at stake. The Crown can merely delay where there's a privacy interest at stake. And that follows from the purposes of disclosure. Disclosure is to facilitate the right to make full answer in defense. Disclosure is not there to protect privacy rights, so the Crown can merely delay in those circumstances. Once the Crown has made that decision, it is incumbent upon the Crown to make a detailed record of what has been withheld or delayed, then to advise defense counsel of that fact and generally describe what has been withheld or delayed if that's possible. On occasion, it may not be possible to even describe it. In the case of an informant, the mere summary of it may reveal the informant. In those cases, it's then for defense counsel to bring a motion before the court to have the issue resolved, or indeed Crown counsel can bring the motion itself to have the matter resolved. In other jurisdictions in the United States, Crown counsel can do so ex parte in circumstances where you can't even have defense counsel there because of an informant issue.
Tim, what would you expect from the Crown as part of its obligation to facilitate a review of the exercise of discretion?
I think ultimately, if counsel cannot agree as to the relevance and materiality and the defense entitlement to access, all disputes where the Crown seeks to withhold material have to be resolved by presumably either the trial judge or the general division judge in the context of a pretrial motion. As defense counsel, you would expect that the Crown has to provide all of the contested material to the trial judge, and although it's necessarily going to amount to a painful exercise, in my view, the trial judge has the obligation of reviewing all of the material himself or herself and coming to a decision as to whether the defense is entitled to it. So ultimately, this is a subject that has to be litigated in front of the court.
I might just indicate that this is a particular problem in drug cases because the police will commonly use an agent to investigate a variety of accused, and they come before the courts at different times. So the federal Crown will often not want to disclose the existence of an agent until all cases have been investigated. That poses a problem for those cases that are before the court, and the Crown is put in a position of wanting to delay disclosure until after the preliminary inquiry has been held to give the police an opportunity to complete all of their other investigations. Where that's done, I think defense counsel may have an argument that they, and some have tried, that they have a right then to reopen the preliminary inquiry once the disclosure is made.
Oftentimes, the defense will take the position during the course of dialogue with the Crown Attorney that they want unfettered access to the investigator's file. The position of the defense is oftentimes said to be, look, I've got instructions from my client that are confidential, and it's up to me to determine if the information that's in the investigator's file may assist in the conduct of the defense. Ryan, is the defense entitled to access to the investigator's file?
In my view, the defense is not entitled to such unfettered access. The Stingcomb case speaks of access to relevant information and the need to establish materiality of that information. Sure, the prosecutor has to err on the side of disclosure, but in my view, that obligation doesn't extend to providing some carte blanche access to the investigator's file. And I might note that the American jurisprudence comes down on the same side as most Canadian cases on that point. It's been consistently held that the rule established in Brady and Maryland does not create the right to what is called in the United States open file disclosure of the investigator's file.
The files maintained by the Crown or the investigators oftentimes include internal memos that outline theories of the investigator or the Crown, or summarize legal analysis or research or anything else that might relate to the conduct of the case. Are those materials ones that the defense is entitled to? Tim?
Well, ultimately, the trial judge will have to resolve the defense entitlement to it. In the Burek case, which Mr. Manishin had some dealing with, Mr. Justice Glithero suggested a procedure to facilitate the resolution of these issues, and essentially the Crown is requested to summarize, if they can, the nature of the material that's being withheld, and then the trial judge, upon a review of that material, may determine what is relevant and what the defense is entitled to access to.
Joe, do you wish to comment on that issue?
The Martin Committee concluded that the defense was not entitled to Crown's notes, correspondence, and legal opinions. Insofar as there's nothing, there are no facts contained in those memoranda or legal opinions. For example, a memorandum on file by Crown Counsel who speculates that a certain witness is a liar is not to be given to the defense. The defense has no right to that. A memorandum on file by Crown Counsel that there is information to suggest that a witness is a liar must be given to defense counsel. And so that's the difference. Matters of opinion of Crown Counsel are simply irrelevant or privileged, and the committee viewed that they should not be disclosed. I might indicate that the committee did, however, provide a right of access to the investigator's file, and that's item 14 in the disclosure directive. It's, the request, however, is to be reviewed by Crown Counsel, who can edit the materials.
Brian, do you want to comment on that point at all?
There may be instances in which defense counsel is entitled to internal memoranda and advice given to investigators. And I'm thinking of two examples. First of all, where the doctrine of abuse of process has been asserted to apply to the proceedings. The presence or absence of good faith on the part of the investigators may well turn on whether they complied with advice given by prosecutorial staff. Secondly, where the defense of entrapment is raised, there may also be some scope for the argument that legal advice given to investigators ought to be disclosed to the defense.
Time being short, let me just raise one other issue, and that relates to the criminal records of witnesses, accused, and co-accused. Is the Crown obligated to disclose those to defense? Joe?
The Crown is required, item 12 of the directive, to provide information about criminal records of the accused and all co-accused. The Crown is required to provide information about criminal records of defense and Crown witnesses if the witness is a material witness, the information is relevant to credibility, and the specific request is made to the Crown. Otherwise, the Crown is under no such obligation in those cases.
It's not unusual for the Crown to become aware of the fact that other government agencies may have some information that's on its face is relevant to the case before the court. What obligation, if any, does the Crown have, first of all, to chase down the information to get it into its actual custody, and secondly, to disclose it? Brian?
The line of cases which has prevailed since Stingcomb is exemplified by Gingras, a case to which I've referred earlier and which is referred to in the paper. Gingras establishes that unless the information is already in the possession of the Crown or the police, there is no obligation on the Crown, as an incident of its disclosure obligation, to obtain information at the request of defense counsel. Classic example may be in a sexual abuse case, Children's Aid Society records. And Gingras also draws a distinction between levels of government and essentially holds that the Crown is not one and indivisible. Now, the Martin Committee recommendations do include a recommendation that some steps be taken to facilitate access on the part of defense counsel. Clearly, the Crown isn't obligated to conduct a parallel investigation to disprove its case, but it may be that as an incident of the prosecutor's duty, the prosecutor can indicate to defense counsel where records can be obtained for the purposes of obtaining a subpoena, for example.
I think that's all of the time we've got for this panel. Thank you very much to all the panelists and for your attendance.